Well, if you've ever watched a crime movie or had the misfortune of being arrested yourself, then you know how the booking process goes. You have your picture taken and you are fingerprinted, and then you are put in a cell to await the next phase of your case. But an increasing number of states are adding another step to that process, collecting a mouth swab for DNA samples. These DNA samples can help local and federal law enforcement agencies solve old and future crimes. However, the American Civil Liberties Union says the process is a violation of an individual's privacy, and they are willing to go to court to end the practice. Northern California's ACLU group filed a lawsuit back in 2009 on behalf of Lily Haskell, the woman you're looking at, who was arrested while attending a peace rally in San Francisco. She was released without being charged, but her DNA is now in California's system permanently. The case will be taken up by the 9th U.S. Circuit Court of Appeals in December. Meanwhile, Pennsylvania is on its way to becoming the 29th state to allow DNA collection upon arrest. To talk more in depth about the case and the broader implications of DNA collection, I'm joined now by Tracy Macklin, a professor of law at Boston University. Tracy, thank you so much for joining me. What are your thoughts on the ACLU's appeal case in California?
Well, I wish the ACLU luck. I think they have a tough road to hoe in the sense that the Supreme Court decision, which you referenced, Maryland versus King, is going to make it very difficult for them to succeed in the long run.
Now, the ACLU said that their appeal case is very different from that Maryland versus King ruling that happened in the Supreme Court. Can you go into a little bit more detail about that ruling and why it matters in this case?
Sure, certainly. Maryland versus King held that the police can take DNA samples of individuals who are arrested for serious or violent crimes, and those samples can then be tested for forensic analysis, and then, of course, if they are hits or matches from the DNA of prior crimes, they can be used in court to help convict the individual. Now, yes, the California situation is different because California law allows the testing of any person arrested for a crime, whether it be a misdemeanor or a major felony. At the end of the day, however, I'm not sure that's really going to matter under the logic of Maryland versus King, because the King decision was based on the premise that the DNA searches are not done to develop evidence to investigate, but rather are done to help identify the arrestee. Now, if you can identify an arrestee with respect to a violent crime, you can certainly, or the state certainly has an interest in identifying an arrestee with respect to a minor crime or a misdemeanor. And I'm sure what the California prosecutors are going to say is that, well, we're taking the DNA to help identify someone arrested for a minor crime.
Now, during the ruling for Maryland versus King, Supreme Court Justice Anthony Kennedy issued the majority opinion, saying, quote, taking and analyzing a cheek swab of the arrestee's DNA is like fingerprinting and photographing, a legitimate police booking procedure that is reasonable under the Fourth Amendment. Now, legally speaking, what is the difference between saying that this material is being used for booking rather than saying that it is being used for solving crimes?
Well, because you're not allowed to conduct searches in order to help solve crimes unless you have probable cause or you have judicial authorization. Now, when they take DNA samples from arrestees, there is neither judicial authorization nor probable cause for the search. And Kennedy, earlier in his opinion, conceded that when the state takes the DNA sample, they are conducting a search. So the problem is that when police and state officials take DNA samples, they don't have any probable cause for those searches.
Now, what about fingerprints? Break this down for us. They are also used in the booking process, and also sometimes it can be run against a federal database in order to solve some crimes. So is fingerprinting potentially a violation of a person's Fourth Amendment rights as well? Does it fall under the realm of privacy? Probably
not, because the court has not yet decided, and probably won't have to decide, that fingerprinting constitutes searches. Now, if fingerprinting did constitute a search within the meaning of the Constitution, we'd have a similar concern. My guess would be that the court would say under those circumstances that fingerprinting, albeit a search, all right, again, is done for identification purposes. And that was the point that Justice Scalia made in his dissent. So fingerprinting is different from DNA sampling in the sense that fingerprinting is not considered a search. DNA sampling is a search, but according to the Supreme Court, The purpose behind the DNA sample is not to investigate possible criminal activity, but rather to help identify the individual who's been arrested.
So is this just the wave of the future when it comes to law enforcement tactics? I mean, years ago we didn't know about fingerprinting, and then we didn't know about DNA, and now we are.
I think, yes, this is the future of law enforcement, and I don't think it's going to be confined to arrestees. Certainly there is the potential. Now, in fairness, the Supreme Court didn't discuss any of this in Maryland versus King, but there is the potential for the police, just like they now take fingerprints from persons who haven't been arrested but say have been detained for investigation. There's certainly the potential for the police to take a DNA sample from an individual who hasn't been formally arrested but is being detained by the police. In fact, it's probably quicker to take a DNA sample than it is to take a fingerprint.
Very interesting. And right now, even in Maryland, 99.96% of the people that they do take those DNA swabs from are innocent. They did catch 13 potential murderers and rapists, so some would argue that it might be worth it. But that was Tracy Macklin, a professor of law at Boston University, with an article on Maryland versus King coming out in the forthcoming issue of the Supreme Court Review. Thank you so much.
You're welcome.